Hello, everyone, and welcome to Uncivil Law. And for today's case, we are combining two of America's favorite pastimes, baseball and human trafficking. This is the case of United States of America versus Julio Estrada. In this case, people were human trafficked from Cuba in order to play in Major League Baseball. Major League Baseball was fully aware of this and helped to traffic the people. And some people are being convicted of the human trafficking, which is bad. So we're going to cover what happened in these human trafficking baseball cases. Let's get started with this. Julio Estrada, a baseball trainer, and Bartolo Hernandez, a baseball manager, partnered with business professionals, human traffickers, and members of a Mexican criminal organization to smuggle baseball players out of Cuba and into the United States so they could enter as lucrative free agent contracts with Major League Baseball teams. We're off to a really promising start. We've got conspiracies with the cartels and all kinds of stuff to engage in human trafficking to get people from Cuba to play baseball. Super exciting. At the time of the events underlying this appeal, Major League Baseball rules required Cuban citizens to obtain unblocking licenses from the United States Treasury Department Office of Foreign Assets before they could enter into free agent contracts. Because at the time we had mixed relations with Cuba, which is maybe changed since then. To obtain these unblocking licenses, the players were required to prove they had moved to a third country with no intention of returning to Cuba. The defense operations would smuggle these people, human trafficking, we'd smuggle them into Mexico, Haiti, or the Dominican Republic, where Estrada, Hernandez, and other co-conspirators would procure fraudulent documents to establish residencies in those countries. Fraud. Very exciting. The players then used the false residency documents to obtain unblocking permits, permitting them to participate. So these people are engaging in a massive criminal conspiracy using cartels in Mexico to funnel these people into third countries, create fictitious documents establishing their residency in those countries in an effort to get them signed up for Major League Baseball. A federal grand jury charged Estrada and Hernandez with smuggling 4 Cuban baseball players into United States law and conspiracy to commit crimes against the United States, and arguably crimes against humanity for the trafficking. On appeal, Estrada and Hernandez raised several challenges to their convictions, including whether the district court erred in ruling that the Cuban Adjustment Act and the wet foot, dry foot policy. Anyone who knows anything about Cuba and Cuban law should recognize these words and cringe a little bit because it's a weird policy. But it did not provide the players with prior official authorization to come in, enter, or reside in the United States. There was sufficient evidence to support their convictions, and the district court committed evidentiary errors. After a thorough review of the briefs, and with the benefit of oral argument, we affirm the convictions. So these people are going to jail for their many bad things. Let's learn more about them. The operation began smuggling Cuban players to Cancun by boat. Once they arrived in Cancun, Hernandez would meet the players and explain the concept of free agency and the necessity of obtaining these licenses, which would allow them to enter into their baseball contracts. To help them establish their residency, which, again, fraudulent, Nacho from Breaking Bad has a side career in human trafficking, I guess. Nacho would pay Mexican immigrant officials to produce false residency documents. The players would list fake jobs like tinsmith and welder on their fake documents, and then they would joke about their fake jobs in front of Estrada. The players understood these fake jobs would allow them to establish fake residency in Mexico. Excellent. Hernandez was responsible for preparing the players on blocking applications. He would include the players' Mexican residency papers in their applications, which were fake. The OFAC granted the applications based on the fakeness, and issued players unblocking licenses which allowed them to enter into their contracts with Major League Baseball. Hernandez also worked on securing visas for the players based on these false paperwork. Once the players received their visas, they could enter the United States. So, we're engaging in fraud, human trafficking, working with the cartel, submitting false documents to official United States government agencies. All kinds of good things happening over here in baseball world. Good times. Let us discuss some of the specific smuggling that occurred. Leon Martin, a center fielder from Cuba, was smuggled out of Cuba with his family by boat and taken to Cancun, pursuant to a plan organized by Lazo and Martinez. In Cancun, Martin offered to pay Laszlo Sr. $40,000 for the smuggling. So we're paying for the smuggling and the human trafficking. $40,000 apparently is the price to smuggle a human, to get him out of Cuba, and requested that he and his family be handed over to a different smuggling organization whom Martin knew from Cuba. Lazo refused the offer. He said Martinez now belonged to the smuggling operation and he owed them $2.5 million. So, yeah, this is the problem with criminals. It's like, how about $40,000 from the smuggling? No, you belong to the cartel now. You owe us $2.5 million. We want a piece of that lucrative back end of the contract. We want $2.5 million, and you are our property now. Excellent, good. Martinez spoke to Hernandez and agreed to pay Bezbal 30% and Hernandez 5% of his major league contract. A normal agent's fee is 5%. This guy's paying 35%. Eventually, the Texas Rangers offered Martin a contract for $15.5 million. So, yeah, he offered the cartel 30% of his contract, so they got $5 million as part of the smuggling operation. Way to go. Great. That's fantastic. Back in Mexico, Martin learned of the attempted kidnapping of one of his handlers. You don't say. Mexican cartel is kidnapping some people. Wow, what are the odds? Afraid of being kidnapped himself, Martin asked Laszlo if the Rangers would still honor his contract if he crossed the border without a visa. Martin and Laszlo met via video chat, and Hernandez joined on the speaker. They asked Hernandez to find out whether the Rangers would honor the contract if he entered the United States without a visa. Later that day, Hernandez called back and confirmed the Rangers would engage in the contract. So Major League Baseball over here is engaging in immigration fraud because they're like, yes, you can cross without a visa, which you need, and we will still honor your contract. So Major League Baseball is in on the human smuggling. That's good news. Or at least the Rangers are. Martinez took Martin to the United States-Mexico border. Martinez crossed and waited on the United States side for Martin. Then Martin crossed. He recited to the border officials what Martinez had told him to say. He was seeking political asylum. A false asylum claim? You don't say. And he'd been in Mexico, where he practiced baseball for 7 months. So he learned the magic words, asylum, and he's going to try to do an asylum claim fraudulently. Great. Shortly after Martin crossed the border, Hernandez had a phone call with a representative from the Rangers baseball team. The contents of the call are unknown, but the Rangers honored the contract and paid Martin, who then paid Laszlo and Martin $1.35 million. Martin paid Hernandez $225,000. Believing the amount to be too low, and this has to be my favorite part, Hernandez filed an arbitration claim against Martin. That is my favorite part of this entire thing, man. This is truly a story of the American way. So for those of you who somehow missed what happened here, just so we're all clear about what happened, the smugglers agreed to like 30% and 5%, which, of $15 million would be $5 million and whatever 5% be, of 15 million, 5% would be, 300,000. Yes, I think I got that right. Anyways, in any case, that wasn't the amount that was exchanged. So the human smugglers over here are sad about being undercut. And so they file an arbitration claim saying, hey, we were guaranteed a greater percentage of our human smuggling contract. We only got $1.5 million. That is the 5% we, the human smugglers, agreed to. There's something very validating about the American way when even the human smugglers can sue for arbitration. Let's learn about another smuggling operation that was completely disconnected from the first. Let's learn about Omar Lewis. Who's Omar Lewis? I'm so glad you asked. He's a Cuban baseball player who was in Haiti waiting for his visa, told that Estrada was eager to enter the United States. Estrada advised him to wait for a visa. Despite this advice, Estrada called Tilbert, who put Lewis in contact with someone who would take him to Mexico and then the United States, again without a visa. Estrada paid Tilbert's contract $1,500. Lewis flew to Panama, where Estrada met him. Estrada paid for the tickets to fly together to the United States-Mexico border town of Reynosa, Mexico. There, they crossed the border without a visa, and was detained by an immigration official in the United States. Estrada, who crossed the border minutes after Lewis, waited for him in Texas. Lewis signed a $4.5 million contract with the Yankees. He paid Hernandez 4% of the contract and Estrada around $200,000 to $300,000. So, another human smuggling operation went by. Let's learn about another one. How about the story of Jose Arbuz, another Cuban baseball player? independently decided he wanted to leave Cuba to play in the Major League Baseball. Estrada paid for Abreu to travel by boat from Cuba to Haiti. In Haiti, Abreu met Letoff, who helped him in obtaining fraudulent papers, lodging, and supplies. Abreu understood that he had to establish residency in Haiti so he could assign the free agency contract by Major League Baseball. Letoff drove Abreu to Port-au-Prince Airport, where I have been before, gave him a Haitian passport containing a false name, more with the fraud, and told him to follow a man named Rogert, who would guide him through the airport. At the airport, Rogert helped Abreu get through security checkpoints, and Abreu was able to board the flight to Miami. After he boarded the flight, he told Letoff's instructions to destroy his passport. So he was given a false passport, and he had instructions to destroy it. So he tore off the cover page of his passport, threw away the rest, he ordered beer, and then ate the cover page of his fake passport. Excellent for a mid-flight snack. Eat the passport, man. Awesome. In Chicago, Abreu signed a contract with the White Sox for $68 million. Abreu paid Hernandez 5%, Estrada 20% of each installment he received under the contract. Let's learn even more about human smuggling in Major League Baseball. How about the story of Dalar Hinojosa and his entry in the United States? Dalar Hinojosa, a Cuban pitcher, wanted to flee Cuba. Estrada worked with Tilbert to arrange Hinojosa's trip to Haiti, with Estrada funded. With Latro's help, Hinojosa received a Haitian passport and is succeeded in establishing residency in Haiti. At one point, Hinojosa traveled from Haiti to the Dominican Republic to showcase for the Major League Baseball scouts. In the Dominican Republic, he met with Estrada and Hernandez and signed contracts for them. He agreed to pay Estrada 30% and Hernandez 5% of his future contracts. Estrada told Hinojosa to wait until he obtained a visa to go to the United States. Hinojosa did not heed this advice. Instead, he paid smugglers $10,000 to send his wife and her friend to the United States. He later paid another $5,000 to send the same smugglers so he could enter the United States without a visa. He then met a friend of Letoff's at the Haitian airport. The man told Hinojosa to destroy his Haitian passport on the plane. When Hinojosa landed in Miami, he told Border Patrol that people at his baseball training complex had paid the $5,000 smuggling fee. That's always a good thing to tell Border Patrol. Hey, Border Patrol agent, it's okay. The people at the baseball training complex have already paid the $5,000 smuggling fee. Good thing to tell the Border Patrol agent. Way to go. In Miami, he stayed at the house. I guess it worked because he got past Border Patrol somehow. In Miami, he stayed at the house of Estrada's business partner, who was an investor in the smuggling operation. Hinojosa signed a $4.25 million contract with the Boston Red Sox and paid Estrada and Hernandez their 35% commission. So I guess it worked out. So, yes, we have learned 4 different tales of 4 different people who were smuggled as part of an ongoing criminal operation to smuggle people in through third country using false passports and telling border agents it's okay. The baseball organization has already paid my $5,000 smuggling fee. But somehow they managed to get into the United States and are playing baseball for many, many millions of dollars. But there was a criminal conspiracy, so we can now go after the human smugglers, I guess. So having learned about these 4 baseball players who were human trafficked into the United States, we now need to learn a little bit about Estrada and Hernandez, the people who were at the center of this criminal conspiracy to generate fake papers, fake passports, and fake documents in multiple different countries, incidentally. So I don't know if Mexico and or Haiti and or the Dominican Republic have any interest in any of this, but there's some criminal liability there too, I would imagine. But let's talk about the United States liability for the minute. So we have to figure out what, if anything, Estrada and Hernandez might be guilty of and whether or not we can sentence them to jail for the human trafficking. Let's find out. Estrada and Hernandez contend the district court erred by rejecting their arguments related to the Cuban Acts and the wet foot, dry foot policy, which were based on the idea that the Cuban Act and the wet foot, dry foot policy provide the Cuban players with de facto authorization in the United States. So, yeah, under relevant law, they're trying to say that, long story short, if you get foot on the United States, you can stay here if you're from Cuba. So they're trying to say that that's authorization. So let's figure out if that qualifies as authorization or not. Before addressing these arguments, we need to provide some background into immigration policy concerning Cuban immigrants at the time of these convictions. So let's learn a little bit about what the law was before. In 1966, Congress enacted this Cuban Adjustment Act, which permitted Cuban citizens to apply for permanent residence if they had been admitted or paroled into the United States and physically present in the United States for at least 2 years. The Cuban Adjustment Act was beneficial to Cuban nationals because it meant they did not have to prove they suffered persecution in Cuba to authorize their presence in the United States. So most countries, they just have to prove you suffered, but Cubans, they get a pass on that one. The wet foot, dry foot policy limited the scope of the Cuban Adjustment Act. Under the policy, only Cuban nationals who had dry feet, meaning they had reached United States soil, could take advantage of the act. If a Cuban national was interdicted at sea and therefore only had wet feet, they would be repatriated to Cuba. So, yeah, this was our policy in the United States for a very, very long time. And it came up most famously with Elian Gonzalez, with the whole wet foot, dry foot, and the whole kerfuffle thing because, he obviously made it to the United States and blah, blah, blah. But yeah, this was the United States policy for a very, very long time. So most countries in the world, if you get to the United States, illegally, that might be a problem. But we gave an exception to Cuba. For whatever reason, we did. And the exception said, if you can make it to our land, then you're all good to go. So you actually had to make dry feet. So that was our distinction and our policy that we had for many, many years and led to some interesting cases along the way. Dominguez was charged with smuggling Cuban baseball players into the United States in violation of law. Before trial, the government filed a motion in limine to preclude Dominguez from submitting evidence of this policy, arguing this evidence was irrelevant to the smuggling. Dominguez argued he should have been permitted to submit this evidence to jury as it was relevant to his intent. He explained he reasonably believed that the CAA and the wet foot, dry foot policy meant that Cuban players were eligible to enter the United States. On appeal, Dominguez challenges the district court's rejection of his arguments related to the law and policies. We affirm the smuggling convictions, concluding that the policies do not provide prior official authorization for an undocumented Cuban to come to the United States. We concluded that the policies pertain to official action which may be taken later with respect to the players, not their prior authorization. So this is one of those wonderful little distinctions in law that can really come back to bite you. There was a policy that if you get here, we will give you a status, but that is an authorization to come here, right? So this is one of those little technical differences where it makes a big difference. We weren't saying we are giving you permission to come. We were saying if you do get here, we will give you status. That is an after the fact correction, not a before the fact permission. And so the smuggling wouldn't apply if he had permission to come to the United States, but you didn't have permission to come to the United States. Now it's true that if you got here, we would do certain things, but that isn't permission to come. So the court is slicing the difference. It's a very technical distinction, but one that makes perfect sense in law and shows how these little distinctions can make huge differences. The defendants argue that the case of Dominguez is factually distinguishable from the present case because the Cuban players in that case entered the United States at a location other than an official port of entry and waited until 3 months after entry to seek asylum, unlike the players here who entered at designated ports of entry and immediately presented themselves for inspection. So they're saying, well, there's a difference because we came through a port of call. But Dominguez's holding was not limited to cases where non-citizens failed to enter designated ports of entry and immediately present themselves for inspection. Its reasoning applies with equal force here because when a Cuban citizen enters through a designated port of entry, a ship port, an airport, a land port, that kind of thing, and immediately presents himself for inspection, he still must be paroled, which is a process that reclassifies an alien from one who's ineligible to one who is legally eligible to remain regardless of how they got affected. So this word parole has a meaning in immigration law that's different from criminal law. So when you talk about parole, in criminal law, you mean, that you're not in jail anymore. In immigration law, it has a different meaning. In parole, it basically is a change of status, which I suppose is true in criminal cases too. We just use it differently. So in a criminal case, when we say parole, we're changing your status. We're changing your status from someone who is currently incarcerated, usually, to someone who's not currently incarcerated but has to go through different protections, and that's a process of being paroled. It's a change in status. So I suppose it's the same there too. It's just not criminal context. So in the parole in this context, we're changing your status from illegal immigrant to legal immigrant. And again, there is a policy that for Cubans, you just need to prove that you have dry feet. But that is not the same. But you actually have to have the change in status. So that process has to be undergone. So that's not the same thing as prior permission. Yes, we will grant you the parole, the change in status, but that's after the fact. That's not before the fact. We weren't saying, yes, please come to the United States. So again, distinction, but one with the difference. Put differently, regardless of whether a Cuban citizen enters as a designated port of entry and presents himself for inspection, the act provides no prior authorization because they offer no guarantee that they will be paroled, because it's a process that has to be undergone through, and that might be subject to discretion. Not the same thing as an authorization. So with the idea that we had prior permission out of the way, we now have to argue maybe the law was unconstitutionally vague. It's not specific enough about what it means to be authorized, therefore it can't be held to me. Now, you should know, without me telling you, that this argument doesn't even begin to make sense. What is authorized is so vague as to be constitutionally deficient. I mean, come on. No. But let's look at their argument in a more technical sense anyway, and discuss why it doesn't make sense. Estrada and Hernandez contend the law is unconstitutionally vague because it does not define prior official authorization. Those words are kind of self-defining. You don't really need a lot more, it seems to me. They further argue that even if the term prior official authorization is well understood, the standards for determining the existence of the authorization are unclear. Not really. Do you have it or not? But let's give that a shot. The plain meaning of a statute controls the interpretation of the statute unless the language is ambiguous or it would lead to an absurd result. A criminal statute is unconstitutionally vague if it fails to give a person of ordinary intelligence fair notice that their contemplated conduct is forbidden. A statute must define the criminal offense with sufficient definitiveness that an ordinary person can understand the conduct that's prohibited in a manner that does not encourage arbitrary and discretionary enforcement. Yeah, so you need official authorization in advance. Are any of these terms so vague you can't figure it out? You don't know what that means? Did you have one? Did you have an authorization? A piece of paper? No, you didn't. Okay, well, no, it's not so vague you can't be held responsible. If there's an interpretation of the statute that makes the statute constitutional, we accept that interpretation, as you should. We hold the statute is not unconstitutionally vague. Prior official authorization means permission to come into, enter, or reside in the United States that an immigration official acquired before actually coming in, entering, or residing. That would mean what the word prior would be. That's a key word, prior, in advance, before. Not that vague. An ordinary person would understand authorization refers to official action taken by the United States government pursuant to immigration law. Right. Did you go to a consulate? Did you get some sort of visa or permission in advance? Did a United States government official do something before you arrived? No? Okay, no. Okay, so we have learned the defendants don't have a claim that this is unconstitutionally vague because prior authorization, you can probably figure out what that means. Yeah. But let's try the idea that there wasn't enough evidence to convict us of the conspiracy for the human trafficking. So it was insufficient evidence. Let's give that a shot. The defendants next argue that the evidence was insufficient to establish they committed an offense against the United States in violation of law. We are unconvinced. To establish a conspiracy under the relevant law, the government must prove that an agreement existed between two or more persons to commit a crime, the defendant knowingly and voluntarily joined or participated in the conspiracy, and a conspirator performed an overt act in furtherance of the agreement. The crime of conspiracy is complete upon the commission of the overt act. We conclude that the government presented sufficient evidence to prove that Estrada and Hernandez conspired in violation of law to bring Cuban baseball players into the United States in violation of law. As we've discussed, the evidence shows that Estrada and Hernandez identified talented Cuban baseball players and partnered with criminal smuggling organizations to smuggle those players into the United States. Estrada either paid for the players' travel expenses or connected them with a contact who would plan and finance their trips from Cuba to the United States border. The smuggling operation paid immigration officials to procure false residency documents, which Hernandez used to obtain the unblocking licenses and visas. Estrada, Hernandez, and other co-conspirators met with players once they crossed the border and assisted them with Major League Baseball negotiations. And Estrada and Hernandez signed contracts with the players, obligating them to pay a percentage of the baseball earnings. The totality of the circumstantial evidence thus supported the jury's conclusion that Estrada and Hernandez knowingly and voluntarily participated in a conspiracy to smuggle Cuban players in the United States. It definitely sounds like that. There's quite a lot of evidence of all these things, including the signed contracts. That's kind of some evidence of conspiracy, yes. For these foregoing reasons, we affirm the defendant's convictions. Affirmed. Thus, this brings us to the end of our coverage of the case of United States of America versus Julio Estrada and Bartolo Hernandez. In this case, we learned that Julio and Bartolo engaged in an ongoing criminal conspiracy to human trafficked people into the United States to play baseball and extorted from them very large fees, 30% of their earnings, to the tunes of millions and millions of dollars. And these people have been convicted of engaging in this conspiracy, defrauding the public, defrauding documents, and so forth and so on. So, yeah, they can enjoy their jail time for their criminal behavior, and that, at least for the moment, is the end of the coverage of this case. Thank you so much for being part of the Uncivil Law family. If you liked this latest video, please give it a like below and hit the join button. For 99 cents a month, you too can give a recurring membership that helps this channel grow and helps YouTube to recommend this channel to others. We really appreciate your continued financial support and all your love. And until later, my friends, cheers and goodbye.